Forest C Donnell was an American attorney and politician who served as a United States Senator and the 40th Governor of Missouri. He served one term from 1941 to 1945. He was the first Republican governor after the collapse of the Thomas Pendergast political machine and the only major Republican elected statewide in the 1940 election. Donnell asked for a revision on 29 U.S.C. 216(b) of Fair Labor Standard Act 1938. According to him, the substantive portions of the Portal-to-Portal Act embody the 80th Congress's pro-business leanings. The act totally barred retrospective FLSA portal pay claims and greatly limited prospective suits. Importantly, the act eliminated representative actions in 216(b) by banning non-employee agents or representatives. The amended version of 216(b) created modern-day collective action, an action to recover the liability prescribed in either of the preceding sentences may be maintained against any employer, including a public agency, in any federal or state court of competent jurisdiction, by any one or more employees for and on behalf of themselves and other employees similarly situated. No employee shall be a party plaintiff to any such action unless he gives his consent in writing to become such a party, and such consent is filed in the court in which such action is brought. Under this new language, only aggrieved employees may represent a class of fellow coworkers. Those who wish to join the suit must opt in to the collective action by giving their consent in writing. This scheme reduces class sizes because litigants must take the extra step of notifying similarly situated employees and awaiting their response. Senator Forest C Donnell pushed section revision of 216(b) in order to ban all actions on behalf of employees who had no knowledge or involvement in the litigation. For even though Senator Donnell did not fully articulate his reasons for promoting the amendment, he likely targeted union-backed suits. Indeed, before the amendment of Section 216(b), unorganized workers rarely brought any kind of FLSA suit, let alone representative actions. However genuine, Senator Donnell also questioned the theoretical underpinnings of representative actions. He deplored the idea of an uninterested party suing on behalf of thousands of unaware employees. In his view, it would be unwholesome if these employees suddenly appeared in droves to collect a favorable judgment well after the statute of limitations had passed. This underlying fear of potentially infinite liability, along with anti-union animus, drove Senator Donnell to lobby against representative actions. As a result, the amended 216(b) facilitated the core policy aims of the Portal-to-Portal Act because it eliminated representative actions and restricted the potential for FLSA claims against employers. On the contrary, the law is not what Donnell thinks it is. It's collective enforcement by federal agency, it's not legislation. What do you think about 29 U.S.C. 216(b) of the Fair Labor Standards Act of 1938? Write your comments in the comment section.